Today's date is the 13th day of May 2026, seated at Pinetown District Court. Before presiding officer Mrs. Robinson, for the state, Advocate N.F. Ngowe is appearing, duly assisted by Advocate Z. Mata and Advocate M.L. Gaba. For the accused, Mr. B. Hendricks is on record. Matter, Your Worship, is on the roll today for a formal bail application. The state is ready to proceed. If I may allow my learned colleague to confirm their appearances on behalf of the accused.
Thank you.
A very good morning to you, Your Worship. I confirm I'm currently on record for the accused before court, the applicant in the bail application. Your Worship, before I address you, may I just take one instruction?
Yes,
Thank you, Your Worship.
So please the court, Your Worship.
Thank you for the indulgence, Your Worship. Your Worship, there's been a change in legal representation for Mr. Adams. We've decided it wise, and the family as well, Your Worship, to maybe at this stage add the Durban spice already and supplement the team that's here currently with members from Durban that will deal with the matter forward. That will also assist practically in that the matter, if there's any postponements, whatever, they can deal with it. And also the matter will be tried in this province, Your Worship. So it's basically if they start and take over now, we will merely take a back seat and observe matters from behind, Your Worship. It was indeed a pleasure appearing in front of you. And I also wish to extend my gratitude to the state for having us here and the way they've treated us and dealt with the matter. Thank you, Worship.
Thank you very much, Mr. Hendricks. Much appreciated. And it was a pleasure having you appear as well.
Thank you, Worship.
Thank you. Mr. Adams, can I confirm with you, sir, that you are now taking on additional legal representatives from Durban?
Yes, indeed. Thank you, Your Honor.
Thank you. So leave to withdraw is granted, Mr. Hendricks.
Thank you, Worship.
Thank you.
As God please, Your Worship. Good morning.
Good morning.
I take my colleagues' sentiment. We are the Durban Spice. I am Advocate Gangai, initial Y. I am instructed by Devin Mudley, incorporated in this matter.
Thank you, Mr. Noble.
So please the court, Your Worship. The state is ready to proceed with the matter. As previously indicated on the previous appearance, Your Worship, the schedule for this bail application is that of a Schedule 1, and we are ready to proceed with the leave of the court. If I may please proceed, Your Worship, the state intends to read the affidavit of the investigating officer into the record in opposition to this bail application.
Thank you, Mr. Adams. You may be seated, sir.
Thank you, Your Honor.
Thank you, ma'am. You can proceed.
As it please the court, Your Worship, before I proceed, may I seek leave before this court to give the court the copy of the affidavit so that the court can follow as I read the affidavit.
Thank you.
The record may also reflect, Your Worship, that I have given a copy of the affidavit to the Defense Counsel this morning.
Mr. Genga, you in possession of the affidavit?
We have received the affidavit a few minutes ago.
Thank you. Thank you, Mr. Noble.
in the Magistrates Court for the Sub-District of eThekwini West held at Pinetown. Case number F245 of 2026. In the matter between the state versus Fadiel Adams, the applicant. Affidavit by the investigating officer. I, the undersigned Sandile Henwell Mavuga, hereby declare under oath as follows. I am a sergeant with service number 703-89675 in the South African Police Services. I am currently deployed in KwaZulu-Natal Province in the Political Killings Task Team to investigate political killings and traditional leadership cases as well as their parallel cases. The facts herein contained are, unless otherwise stated or indicated, within my personal knowledge and belief, both true and correct, and I can and do swear positively thereto. I was appointed as a member of the South African Police Services in terms of Sections 30 of the South African Police Act 68 of 1995, and I hold the rank of a sergeant. The objective of the South African Police Service is to protect, combat, and investigate crime, to maintain public order, to secure the inhabitants of the Republic and their property, and to uphold and enforce the law. I have about 21 years of experience in the South African Police Services, of which 15 years is in the investigation environment. Brief background of the case. I am the investigating officer of Westville SAPS case 2 of 4 of 2026 on charges of fraud and defeating the ends of justice. The allegations against the applicant is that he, as a member of parliament, visited the Westville prison to interview and video recorded an interview with an inmate, Bonginkosi Anthony Dlamini, a former SAPS sergeant. Mr. Dlamini was charged with corruption and defeating the ends of justice as per docket Pinetown case 578 of 10 of 2019. Mr. Dlamini was charged with several other accused and was kept in Westville prison after his bail application was refused. He pleaded not guilty to the said charges. At the time of the interview, 2nd November 2024, Mr. Dlamini was attending a partly heard trial of S versus Bonginkosi Anthony Dlamini and 4 others under court case number RC 293 of 2020 in Pinetown Regional Court. He was legally represented by counsel. The trial matter was sub judice because the judgment on the merits was not yet given. It is further alleged that the applicant visited Westville prison on 2 separate occasions. In those 2 occasions, he interviewed another inmate, Mr. Sindiso Magaqa. He further obtained a statement from the said Mr. Sindiso Magaqa. The interviews were held with Mr. Magaqa on the 20th and the 24th of January 2025. At the time of the interview, Mr. Magaqa was appearing in a partly heard matter of S versus Sibonelo Miyeza and 3 others under court case number CC 34-2019-P, which matter appeared in the Pietermaritzburg High Court. This matter involved the killing of a former ANC Youth League Secretary General, Mr. Sindiso Magaqa. At the inception of that trial, Mr. Magaqa pleaded not guilty to the charges. State led evidence of several witnesses in proving its case. Mr. Ngengo was represented in the said trial by counsel appointed by the Legal Aid Board of South Africa, Pietermaritzburg High Court Section. Several state witnesses were already called in the matter. The matter was in the process of further evidence being led by the state. During November, December 2024, the investigating officer and his team of the docket Pinetown Case 578 of 10 of 2019 became aware of the social media video footage showing Mr. B.A. Dlamini inside a Westville prison office wearing prison uniform, explaining himself and alleging his innocence of the charges that he was facing. This worried the team and it had to be investigated. The investigating officer of Sindiso Magaqa's case became aware of the statement and recording trending on social media as well as on print media, a newspaper article in January 2025 about a statement that was obtained from Mr. Ngengwa wherein he was implicating his co-accused and others in the killing of Mr. Magaqa. This came as a surprise because no arrangements were made with him or his team for such. The matter was also partly heard and sub judice at the time. This also prompted an inquiry as to how the recording and the statements were obtained during such a critical and sensitive stage of the two cases. I was subsequently assigned to investigate this matter, which is prosecutor-guided investigations, and part of my investigations led to the interviewing and obtaining of several witness statements which explain how the applicant, Mr. Fadiel Adams, committed the offenses he is charged with. Evidence on the case. Witness statements obtained from several witnesses revealed the following. 15.1. Mr. Fadiel Adams arranged to come to Westville Prison to interview two inmates, including Mr. B.A. Dlamini, on the 2nd of November 2024. He arranged same and presented himself on official capacity as a member of Parliament or National Assembly conducting parliamentary duties. 15.2. As a result, he was allowed to conduct those interviews with the said inmates. On arriving at Westville Prison, he was informed by the officials of the Department of Correctional Services that as per their standard operation procedure, a visitor inside the prison is not allowed to go into the prison with a cellular phone. He insisted to go in with the said cellular phones and cited that he was going to use them as part of his parliamentary duties. He even showed them his parliament identity card as proof of his official duties. 15.3. He was allowed into the prison with the said cellular phones in violation of the DCS policy that regulates access control by ensuring that no visitor is allowed to consult, interview an inmate whilst in possession of his or her cellular phone. He took a video footage of Mr. B.A. Dlamini inside the prison, showing the inside of an office therein. After doing so, he arranged for the said footage to be circulated on social media. 15.4. During January 2025, the applicant, Mr. Adams, arranged with a member of the South African Police Services to arrange official police or Metro Police blue lights and sirens escort from King Shaka International Airport to Westville Prison and back. Once more, he presented himself as being on his parliamentary duties as a member of parliament. The said escort was arranged at the cost of the state. He was escorted from King Shaka International Airport to Westville Prison and back. 15.5. As part of evidence, my team and I have obtained copies of WhatsApp messages confirming the applicant's request for blue light, escort from King Shaka International Airport to Westville Prison and back to King Shaka International Airport. Statements from those who escorted him have been obtained. The applicant, in his recent media utterances and media briefings, does confirm that he indeed requested such escort. These will be played in court. 15.6. In the two visits there, on the 20th and on the 24th of January 2025, he conducted an interview with Mr. Sibusiso Ngengwa. Once more, he insisted as before to go in to the prison with his cellular phones as part of his parliamentary duties. On the 20th of January 2025, he recorded an interview with Mr. Ngengwa on his cellular phone and left. He arranged to come back. 15.7. He did come back on the 24th of January 2025 after having arranged a member of the Directorate of Priority Crime Investigations, DPC High, Hawks, to come and assist him to interview Mr. Ngengwa. He met the DPCI member in Westville Prison and insisted that the member records Mr. Ngengwa's interview on paper. At first, the member was to assist with interpretation in view of the language barrier between Mr. Ngengwa and the applicant. At the end of the said interview, I'm now at 15.8, my apologies, a sworn statement was obtained from Mr. Ngengwa, who mentioned his involvement and that of his accused and others in the killing of Mr. Magaqa. The applicant arranged for the said statements to be circulated on social media. It was also articled on a Sunday national paper. This statement was obtained in the middle of a partly held trial matter. The interview and obtaining of the said statements were done without the legal representative of Mr. Ngengwa, the investigation team, and the investigating officer of the case knowing about it or any permission granted to hold such an interview. 15.9. He managed to conduct interviews, recorded a video, and obtained a statement from inmates at Westville Prison while under the disguise of conducting parliamentary duties. 15.10. I have obtained a statement which supports the fact that the applicant was not on parliamentary duties but was rather acting on personal capacity during his Westville Prison visits, since he never reported these visits to Parliament or to Portfolio Committee on Policing. Paragraph 16. From all the statements obtained, it is clear that the applicant's intentions were to redirect, obstruct, disturb, and/or defeat the course of the ongoing investigation in Sindiso Magaqa's case, to influence the outcome and to undermine the work of the political killings task team on the cases of Bonginkosi Dlamini and other matters. The applicant has, on numerous media briefings, have been criticizing without merit the work of the PKTT. This will be apparent on the recent video footages to be played in court. He circulated at the time he knew there was a warrant for his arrest. The members of the Magaqa family were shocked to see the statement of Mr. Ngengwa on social media and the newspaper article. They indicated that they were never approached by the applicant to hear their views about what he was engaged in and felt that their feelings as a family were not considered by the applicant in such a very sensitive matter, more so the stage the matter was at the time the statements was published. They felt the applicant was callous in his conduct. Evidence which led to the arrest of the applicant. Paragraph 18. Based on my investigation findings and evidence collected, I then applied for a warrant of arrest, J50, against the applicant in order to have him appear before the court of law. The warrant was then authorized at Pinetown Magistrates Court, KwaZulu-Natal, on the 30th of April 2026. Paragraph 19. I, together with my team, conducted standard profile of the applicant and identified 2 possible residential addresses in Cape Town: Mitchell Plain, and on Saturday, 2026 May 2 at about 4:30 in the morning, we proceeded to both addresses in an effort to trace him. However, he was not found. Paragraph 20. We were informed that House 66, Kunhoop Street, Westridge, Mitchell Plain, Cape Town, was sold in March 2026, and the applicant was no longer residing there. And at the second address, 50 Disa Crescent, Mitchell Plain, Cape Town, he also was not residing there for a long time. Paragraph 21. On the same Saturday during the morning, while still trying to trace the applicant, I became aware of a video footage of the applicant indicating that he is aware that the PKTT is looking for him and that they had visited his residential addresses, which he no longer resides at. He has also opened a case of intimidation against the police as he believes that the PKTT has no J50 against him. See video clip marked SM1. With the leave of the court, Your Worship, if I may ask that at this stage, before I proceed further with the reading of the affidavit, so that we can also follow properly, that we play the video footage, or rather the video clip marked SM1.
Mr. Genga?
No objection.
Thank you. You can proceed.
At 4 a.m. this morning, the house that I used to occupy was raided by approximately 15 policemen clad in balaclavas like the criminals they are. They wore no name tags. They parked their vehicles 100 meters away from the scene, around the corner so no one could take registration. They cut the locks of the house. They were going to bang down the door when the occupants opened. This woman was met with a rifle to her face. Her husband was made to lay on the ground. A 12-year-old son was slapped because they were looking for Fadiel Adams. Now, with a budget of hundreds of millions of rands a year, this is now become like intelligence. They couldn't get the address right. They raided the wrong house. They abused the wrong family. But my question right here is, when the woman demanded a warrant, they wouldn't show her one. Now, what kind of policemen do we have in this country who operate with closed faces like gangsters, who point guns at children like gangsters, who operate with impunity like gangsters? There was no warrant shown. As far as I know, if this is the PKTT, I'm accused of many things, but not being part of a political killing, or having planned a political killing, or having links to political killings. If these people are overstepping their mandate, then answers must be forthcoming. I need to know why these people are looking for me. As a matter of fact, I can produce an email for you right now that I wrote to Minister Kachalia, where I copied Mkwanazi and Masimola in. And I said to them, generals, I'm aware that the PKTD is planning something unlawful. I'm letting you know that I'm willing to comply. If you have a warrant for my arrest, I'll hand myself over to the police station. If you want my cell phone, I'm willing to hand it over. There was no need to send thugs with rifles to come and look for me. If there's a warrant, I'll pick up the phone, you have my number. I'll happily come to the nearest police station. But this is not how they operate. They use fear, they use intimidation. But I have news for these boys. I'm not fearful, and I can't be intimidated. And I'm not going to stop. You're going to jail.
So please, the court, I'll continue from paragraph 22. On Sunday, the 3rd of May 2026, my commander, Lieutenant Colonel Magila, informed me that she was sent an email by Acting Crime Detection Head in KwaZulu-Natal that sometime in April 2026, the Provincial Commissioner was copied on an email by the applicant, Mr. Fadiel Adams' attorney, indicating that should there be a warrant of arrest, J50, issued for him, he will hand himself over to the nearest police station, and that Mr. Shahild will represent him. I attached the said email communications between Lieutenant Colonel Magila, Acting Crime Detection Head, as SM Email 1. Paragraph 23. Lieutenant Colonel Magila further informed me that on the same day, the 3rd of May 2026, she called Mr. Shahild Skuda and informed him of the request made on the letter that should the police have a warrant of arrest, J50, for the applicant, he then he will hand himself over at the nearest police station. The attorney requested that Lieutenant Colonel Magila grant him time as he has not spoken to the applicant in 3 months, and the applicant has changed his cellular phone numbers so many times. He further said he has no knowledge of such agreement made with the applicant and will have to inquire from the applicant's political party members. The attorney promised that should he find the applicant on the phone, he will arrange that he hands himself over at the Cape Town Central at 10. As I was in Cape Town, paragraph 25, still trying to trace the applicant, I was informed by my commander, who indicated that she saw on social media that the applicant, Mr. Adams, will be making a press briefing on the same day, the 3rd of May 2026, Sunday, at 10. She indicated that it has not yet been confirmed, but my team must go to Parliament to make inquiries and request for the applicant to meet with them so they can show him the J50 warrant of arrest and process him. Paragraph 26. When we arrived at Parliament, my team and I were refused entry in order to verify if there was such press briefing indeed. Due to this, I communicated with my commander, who advised that since she was in communication with the applicant's attorney who had promised to locate the applicant and advise him to hand himself over to us, we should respect that process and not bring the Parliament image into disrepute. Paragraph 27. Later, I then noticed on social media that the applicant was holding a press briefing in Parliament. regarding his warrant of arrest. I attach the video clip marked as SM2. Again, Your Worship, I will request that the video clip marked SM2 be played before I proceed reading the affidavit.
Thank you.
I serve on the police portfolio where we attempt to hold South African police accountable. Accountability does not exist within the South African police service. These people are working on themselves. On Saturday morning at 4 a.m., my previous residence was raided by the police. I no longer live. With a budget of hundreds of millions of rands a year, this cannot be responded to at this time. The result of this, an innocent teacher, a 50-year-old female, had rifles pointed in her face. Her husband was made to lay on the ground in the middle of winter. A 12-year-old son was assaulted by something that came to be a police officer. Who assaults a 12-year-old child? Physically, because he woke up startled. This happened. A case was laid. I then went to the police station and made a case of intimidation against the South African Police Services. I do believe that this raid is engineered by Lieutenant General Mkwanazi, the self-proclaimed savior of the South African Police Service. The weakest form of police commissioner this country has had in 30 years. The coward from KZN, who ran away when the country needed him. And I'll tell you why. In the Arab committee, he claimed that I used a blue light escort to the prison in Westfield. I was indeed escorted by Metro Police, not the South African Police Services, to the Westfield prison. While on my official duty. Because I went to Westfield prison to interview the killer of one of our finest, Sindiso Magaqa. I think this country's forgotten about him. He was killed for it. He was killed for exposing corruption in Durban. The killer has given me a written statement saying that he was escorted to the crime and from the scene by the South African Police Services. The killer wants to tell the truth. He wants nothing in exchange. Not a reduction of sentence, not a financial reward. Mkwanazi hasn't sent a single policeman to go and hear this man's story. Not one. What Mkwanazi has done is insinuated to Parliament that I've committed a crime. In the Arab Committee, Mkwanazi has said that there will be a conference call later where you will hear something about Adams. What you were supposed to hear was that Adams had contrived or corrupted or abused his power, whatever power he thinks I have, to obtain a blue light escort. The person implicated, the person who was supposed to make the statement is Detective Sergeant Carlton Thomas, who has laid a charge against Mkwanazi and Major General Gopal, because he claims that they forced him into a room where the cameras were set up and had written a script that he was supposed to incriminate me in front of the Arab. He refused. Therefore, that conference call didn't happen.
Say please the court, Your Worship, if I may proceed from paragraph 28.
Yes.
My commander informed me that
Continue.
my apologies, Your Worship.
Can continue.
Continue. It's a pleasure. Paragraph 28. My commander informed me that she was contacted by the applicant's attorney, again, Mr. Shahil Scooter, who requested to facilitate the applicant's handing over at Cape Town Central Police Station on Monday, the 4th of May, 2026 at 10, which was agreed upon. My commander informed me that he told the applicant's attorney that the team will continue tracing the applicant in addresses linked to his profile. Paragraph 29. On the 4th of May 2026, the team continued tracing Mr. Adams at 2 further addresses he once lived in. However, he was not found. After the search, I later noticed that applicant went on social media again and indicated that he is aware that the PKTT is continuing looking for him and he wants to give an update. I attach video clip as SM Part 1 and Part 2. With the leave of the court, Your Worship, may I request that these clips be played before I proceed with the affidavit.
Good evening, everybody. Very good evening. Hey, veel wat ik gewoon in Pakistan. Allemaal slapen. 10 o'clock, dat is net die PKTT wat is nou. Ja, PKTT. Ik zie jullie loop naar zonder masks. And I see that you're not pointing your rifles at women anymore. En dan veel komen manieren te leren, joh. Kijk, dat was wat how are you doing? Mr. Jamaluddin, assalamu alaikum. Hoe gaat het met jullie? What a day. God, I must tell you, if there's one thing I still believe in this country is I believe in our judicial system. I think the South African police service is stuffed, I must tell you that. But our judicial system, I have so much faith in that thing. Maybe until I lose a case and then I'll change my mind. Listen, I'm just here to give you a quick update on what is transpiring at the moment. Let's just feel a minute more. It's not for some people to join us. Welcome, that's it, right? Mr. Clayton, how you doing with Kekisa? Uncle Brian Warden, how are you? 116 is here. Zaki, Shelly Daniels. You know, I remember a movie in the late 90s. I think it was Harrison Ford, called The Fugitive. Yeah, I thought that was smart. But you got nothing on me. I can get it. I'm like a Black Michael Schofield or something. Anyway, let's just give it a minute. 54 license, bro. And Randall Adams, no relation, how are you doing, son? You know, it's been a mad weekend. For those of you that don't know, you know that the PKTT tried to arrest me. Hit the wrong house in the process. Masked. Assaulted a young boy. Pointed rifles at a woman. Tonight they hit my late sister's house, where only my niece and my nephew live. I don't think I've been to that house in maybe 6 months. But they went to the raid there looking for Fadiel Adams. Their faces were uncovered, alhamdulillah, thank you. They didn't point rifles at anyone and they didn't assault any children. Yeah, you had to come from KZN to come learn manners here in the Western Cape. Those are the elements here. So, just a very quick update. Tomorrow, we expect some type of court action because we are challenging this warrant that Kumaro's team have pulled. We are challenging it with a very strong legal team. And let's just say I have lots of faith in the judicial system. Lots. But what I'm here to tell you is that it's going to be alright. NCC is going to be alright. The South African police services will be alright as soon as we cut out this fucking cancer. And the country is going to be just fine. That's what I'm here to tell you. And then I have a message for General Dumasani Kumalo. So, yeah, I'm steering. So, what I'm trying to say to you is, General Dumasani Kumalo, Lieutenant General, DIVCOM of Crime Intelligence, which has no intelligence, and Commander of the Political Killings Task Team, which does anything but investigate political killings. I have a message for you. Your team better have a warrant for me. Because
Your refusal to show the warrant to my attorney is telling. The fact that you're refusing to show the warrant everywhere you go is telling. The fact that you're so desperate to arrest me on bullshit charges, whoever you are, that you are now harassing my members and my family. Life into Nazmi's daddy also. That even Nazmi's arma upa arrest. I didn't know I was the country's #1 terrorist. But meanwhile, he's trading with Wusikat Maklala. And you couldn't arrest him. It's amazing. It's funny. Funny how things work. But I tell you again, I've got lots of faith in the judicial process. I put my faith in the courts. We've placed our evidence in our submissions. Our submissions are somewhat explosive. You know, there's things in there, generals, that you don't want the public to know. There's things in there. A judge is going to see. There's things in there that is going to fuck shit up. So yeah, I'm not in hiding for anybody that's asking. I'm moving around freely. I was actually at an NCC meeting tonight, believe it or not. I drive around, I walk around, because if you find me, you arrest me, that's fine. But if you're insisting that I hand myself over to a team known for assaulting and killing people because they say they have a warrant that they won't produce, then you don't understand Cape Colors. Ons is 'n ander soort species. So, General, the ball is in your court. You produce that warrant, or there's going to be out. I'm not afraid of coming to KZN. That was my plan. My lawyers took me out. I want to come to KZN. I want to face your charges. I want to beat your charges. And then I want to retire what I'm going to sue you for. Because what's been happening here, people have been getting away with this shit for way too long. Isn't it an amazing thing? We've all known how corrupt the South African police services is. Even when Nazi said it, I didn't say it. But thus far, I'm the only one to have gotten policemen in court and locked up. Colored boy, Lemondale, no education. Yeah, education is important for Nazi. Education is so important, no? That we still concentrate in our place again. So, people, they told Nazmi, they are demanding Nazmi must come and meet him. You don't have a fucking warrant for Nazmi Jacobs, man. I'm starting to believe you might not have a warrant for Fadiel Adams. So, well, there's also a line, an email from a very famous general from KZN, but we'll talk about that in court. Guys, be safe. This is just the beginning. We're going to clean up the South African services, South African police services, with the support of South Africa or without it. Because South Africa is falling in love with a band of criminals. Carlo Anja, he is one of the finest policemen this country has ever produced, and he happens to be a colored. There he is, honestly. That man won South African Policeman of the Award twice. He won the award for South African Policeman of the Award.
Thank you. I think that this would be an appropriate time just to stand down briefly so that I can deal with the other matters.
As it please the court, Your Worship.
Thank you, Mr. Adams. I'm just going to be dealing with the other persons from Westville. We had stood down, so we will recall your matter as soon as we finished with you.
No problem at all, Your Honor. Thank you.
Thank you.
hand himself over at his nearest police station without delay. Media enquiries, Brigadier Atlenda Martin, cell phone number 082-040-8808. Paragraph 32. I was then notified by my commander that the applicant, Mr. Adams, is on TV making a press conference and was indicating that he will hand himself over to the police after his High Court application on Tuesday, the 6th of May 2026. See video clip SM part 1, 2, 3, 4, and 5. With the leave of the court, if those clips may please be played.
Thank you.
The South African Police Services, headed by a bunch of illegal criminals, is giving the last kick of the dime offs. They apparently have been looking for me since last week. They have my email. They have my residential address at Parliament. They've never approached me because they wanted to arrest me for drama. They wanted to do that. They never got it. We approached the SABC through my lawyers and said, we are willing to hand ourselves over. But what are you charging me with? They wouldn't disclose any information. We asked, which court do you plan to take me? They wouldn't disclose. Simple information. On this basis, we went to the Cape High Court, and the High Court gave us an order yesterday that the SABC must disclose all of the documentation. Now, what we know for a fact is that there's nothing in that document, because I've done nothing wrong. This is intimidation. Intimidation by the head of the PKDT, General Dumisani Kumar. The PKDT is headed by an alleged criminal, who I put before the dock. I lay those charges. Now, this man is using his unit and his resources to intimidate me. It's that simple. What they say I've done happened a year ago, and I reported it to Parliament. I brought it to Parliament. I did not hide it. If there was criminal intent, why didn't they charge me a year ago? Because they never thought that they'd be going to jail. They never thought they'd get arrested. But now dozens of generals are before the court because of the work of the NCC. This is the apartheid smear campaign, because these are apartheid operatives. Remember, these people stuff the gun. They know how to do it, but I'm not afraid. Let them come. Tomorrow morning we'll be in court. Trust that the judge will make the right ruling, and we will take it from there. Let me make it clear. I'm 10 years of my day. They are charging me. I'm not running away from them. What we are disputing is this proper? Why wasn't I given a warning statement like every suspect should be? Why jump for a warrant? I'm not a flight risk. I'm a member of Parliament. I'm the member of Parliament holding them to account. And they don't like it. Because they don't think they're accountable. But they are. Tens, hundreds of millions of rands are stolen in this country every year by senior policemen. And we are not happy with the status quo. We lay charges. They get arrested. They react. Let them react. I want to encourage you. React harder. Because if this is what is meant to intimidate or stress me, you people clearly don't know where the threshold is. Push harder, guys, because I'm not going to stop. Thank you. Attorney contacted them, and we have the emails and said, my client is happy to hand himself over. What is he being charged with? They didn't want to tell us. But now they can tell the nation. This is nothing more than a smear campaign. But Dumisani Kumalo, hou vir jou sterk. Fadiel Adams is coming.
Fadiel, sorry, just for a bit of clarity on the statement that you brought to Parliament, if you can just give us a bit of detail of what was in it.
The statement alleges by a convicted killer, the hitman, the man who killed Sindiso Magaqa, one of our best. He alleges that Dumisani Kumalo is involved in the plot to kill Sindiso, because Sindiso was exposing corruption in KZN, as I am doing in Cape Town. So this poor man was killed for doing the right thing. But then the hitman takes it further. He says that we were escorted to the scene of the crime and from the scene of the crime by crime intelligence. Then he takes it a step further and says, oh, by the way, the AK-47 we used to kill that man, it was bought with the money from crime intelligence. Do SABC react on the statement? No. What do they react on? The man that brings the statement to Parliament. Is this what South Africa accepts as policing? When
obviously will state categorically, I'm going to assume that you were not interfering with that process, you were engaging in parliamentary work, and there was nothing wrong with you as a member of Parliament doing your work and making that visit to Parliament? Because ultimately, what are you trying to do? You are trying to ensure that the rogue elements within the South African police services are taken out. That's a fair characterization, is that so?
Here's the issue with interference. It did mean that I tried to either intervene or drive an investigation in a specific direction. I did none of that. I've never been in touch with the investigating officer. I've never been in touch with any of the witnesses. I've only ever spoke to the killer, and I reported it back to Parliament. What Parliament did with it, that's disappointing because Parliament did nothing. What SABC did with it, that's criminal because SABC have done nothing. How can it take you 5 years? They've never been to see the killer. Never. How can it be at a sensitive stage when they've never spoken to the killer? When I showed them the affidavit in Parliament, but they never asked me for it. How can it be? Is this what we're going to accept as policing? That General Lincoln told me that my safety would be taken care of when I got to Joburg. Now, when you compare what I did in Durban to what's happened at JMPD, this is a stupid comparison. No money was exchanged. No one benefited financially. It was a simple trip to a prison so the truth would come out. Now, the sad fact of all of this, let me finish. I benefited how?
Because if you needed protection, you either needed to have that paid for, or you needed to have it sanctioned by the parliamentary process. I don't hear you saying it was sanctioned by the parliamentary process, so therefore it became something that was your personal
If I told you it was sanctioned by the parliamentary process, I'd be lying to you. No, no, no. This is not about my personal interest. This was about the interest of the South African public and the interest of the South African police services. Now, I could have requested a police escort, but when the police are the people doing the killing, what do you want me to do? It is easy for you to sit there and criticize. It is not that easy to get the job done. Go and ask the other 309 MPs in Parliament why nothing is being done. This is, in my view, this is a stupid question. I think you're dragging it. I thought we came here to discuss the warrant, the killing of Sindiso, but all you're going on about is a 10-minute trip. I don't get it.
If the trip was an hour, would your office be any different, Fadiel?
Let me finish. If the trip was?
If the trip was an hour, would your answers to my questions be any different? You seem to reduce it to a 10-minute trip, as if it is not significant to the use of state resources.
My answer would be exactly the same. It would be exactly, and you're saying, talking to me about the state resources. This was about state resources. This was about the plunder of state resources. Something that you're keen to avoid.
No.
Before you ask me a question, I just want to make a statement that the PKTP has entered the parliamentary precinct. They are inside here, believe it or not. You must understand that the executive holds no right over the register. They don't belong here. That's why you have parliamentary police. Parliamentary police is allowing me to. I'm not going to fight this. We're going to do this. Yeah, come on. I'll see you soon.
Will you be handing yourself over at the Grassy Park police station?
I don't know which police station they're taking me. You know what these people, you never know.
You're going to surrender to them?
Yeah, I'm just coming to put on socks and a jacket because of my arthritis. Listen, long story short. I was going to say, I confirmed that with you 5 minutes. I just said we want to go to court tomorrow to test the validity of this business. Right? They couldn't wait for it because they got lost eye. There it is. They're not supposed to be on the streets. They know this. These people have no respect for it. I don't think South Africa understands the trouble that you're in. You have policemen acting with impunity. These people have torn up the Constitution. They've killed people that have exposed their corruption and their theft. And now they're after the whistleblowers. Patricia Mashali, sister, hide away. I fall. They're coming for you next.
Thank you.
Thank you.
Secretary of Court, I'll proceed from paragraph 83.
Thank you.
My commander informed me that she recognizes the place Mr. Adams was conducting his press conference in and directed us to the place as she was in Durban and we were in Cape Town. We then proceeded to the directed address, which was not on Mr. Adams' profile list of addresses. And upon arrival, we were assisted by Lieutenant Colonel Mashele, who went inside the parliamentary residence to inform the applicant that we were outside the gate and that we were in possession of a warrant of his arrest, J50. Paragraph 34. The applicant refused to cooperate with Lieutenant Colonel Mashele and even declined the Lieutenant Colonel's offer to drive him to the nearest police station with a state motor vehicle. The Lieutenant Colonel then came to us and informed us that the applicant was busy with the media and did not want to come to us. He then opened for me and my team to execute the J50 warrant of arrest. Paragraph 35. The warrant of arrest was accordingly executed on the applicant, and he requested an opportunity to go fetch his jacket, and we accompanied him to the house where there was a lot of media houses outside. Whilst inside the house, we advised the applicant to take everything he needs, including medication, and he said it's fine. Some of the things will be brought to him at the police station. We proceeded to Cape Town Central Police Station and booked him for transit to KwaZulu-Natal, being free from injuries and without any complaint. Considerations in terms of sections 60, subsection 4A to E, read with sections 60, subsection 5 to subsection 9 of the Criminal Procedure Act. I now tend to deal with the relevant considerations and factors as set out in section 60, subsection 4A to E of the Criminal Procedure Act. A. Likelihood that the accused, if released on bail, will endanger the safety of the public or any particular person or will commit a Schedule 1 offense. Section 60, subsection 4A, read with section 60, subsection 5. Paragraph 36. The applicant's utterances and conduct indicate his resentment against the PKTT. He is presently charged with interfering with matters investigated by the PKTT. He has, on numerous occasions, made public comments that may be viewed as defamation of character against the PKTT and people he perceives are linked to the PKTT. Same can be seen on the video footage played in court. Paragraph 37. During the year 2023, an order was issued against the applicant by an equality court after it was found that he made utterances against the City of Cape Town municipal manager. He was, amongst others, ordered to remove the social media post containing the utterances and prohibited speech. Paragraph 38. Instead of adhering to the court order by the Equality Court, he posted again disregarding the said court order. I attach the said court order and his post as SM5. Paragraph 39. His disregard of the said court order led to the complainant, City of Cape Town manager, to open a criminal charge against him under docket Cape Town Central Case 311 of 3 of 2024. He was brought to court for that. The National Prosecuting Authority intervened and there was mediation between the parties, which led to the charges being withdrawn. Paragraph 40. This has not stopped the applicant from making reckless statements without facts despite his past conduct. He continued calling people names and using language that may be interpreted as insulting, defaming people's characters. It all depends on those he labels names and defame their characters to open cases against him. The video clip that we played in this court, the video clips that we played in this court are evident to that. There is all likelihood that he will continue doing so, and he has done a disposition to continue doing so. B, likelihood that the accused, if released on bail, will attempt to evade trial. Sections 60 subsection 4B, read with sections 60 subsection 6. The applicant's conduct after he was made aware of the warrant for his arrest is indicative of someone who is prepared to evade trial. It took a lot of efforts to trace him. He deliberately switched off his phones when outside the parliamentary precinct. His own attorney struggled to get hold of him. He himself mentioned in one of the video clips that he is a fugitive, and even linked himself to the well-known actor Harris Ford in the movie The Fugitive. He made fun of the South African police services and the criminal justice system. The charges he is facing are indicative of that. My team and I were provided with a deed of transfer for ERF 2224 Bater Freden Valley, situated in Cape Town, in the name of Letitia Nelline Adams, transferred on the 21st of January 2026 as proof of residence for the applicant. His name is not mentioned in the deed of transfer. There is therefore no documentary proof that this is his property. The other addresses given is the parliamentary precinct on which he resides based on his position. Should that position change, he will cease occupying that place. In all intents and purposes, the property belongs to the Department of Public Works and not him. Paragraph 44. The applicant is facing very serious charges which he partially admits on his video clips to have committed, and faces jail sentence that might make him lose his position as a member of the Legislative Assembly Parliament. This on its own is an incentive to evade trial. In the circumstances, paragraph 45, there is all likelihood that the applicant will attempt to evade trial. C, likelihood that the accused, if released on bail, will influence or intimidate witnesses or destroy evidence. Sections 60 subsection 4C, read with sections 60 subsection 7. The applicant, upon learning of his imminent arrest, contacted several times a state witness he knew was involved in the matter. He wanted the witness to send him a statement that he made to the police in this investigation, and same to be sent to his official parliamentary email, f.adams@parliament.gov.za. Paragraph 47. Even before his arrest, the applicant already interfered with the state witnesses and demanded a sworn statement the witness made to the police. I attach a statement from the said witness with names retracted, SM6. Paragraph 48. It is a well-established knowledge that the applicant was in possession of classified information of crime intelligence. He alleges that same was put under his door and he found it there. Whether this is true or not still stands to be proven. The fact of the matter is that he was in possession of classified information. Paragraph 49. The conduct of the applicant indicates that there is all likelihood that he will attempt to influence witnesses he has already started, or conceal or destroy evidence. The very same charges he is charged with are indicative of this. D. The likelihood that the applicant will undermine or jeopardize the objectives and proper functioning of the criminal justice system or bail system. Section 60 subsection 4D read with sections 60 subsection 8. Paragraph 50. There was a court order issued by a competent court against him. He did not challenge it or appeal it. He did not comply with it instead. On his social media post briefing, a member of parliament and lawmaker gave the court a middle finger. The language used in his post is indicative of someone who does not respect our courts. 51. As indicated earlier, he continues defaming people and calling them names. For example, criminals, whereas there is no proof that those people have indeed been found guilty of any criminal offenses. He does not respect the South African police services. Paragraph 52. The past and present conduct of the applicant indicates that there is all likelihood that he will undermine or jeopardize the proper functioning and objectives of the criminal justice system. Unethical conduct displayed by the applicant towards his arrest. Paragraph 53. The conduct of the applicant has undermined the integrity, authority, and public confidence in the South African police services and the criminal justice system as a whole. His actions have created a perception that the law processes can be manipulated, obstructed, or disregarded without consequence, thereby weakening the rule of law and the administration of justice. Paragraph 54. Furthermore, such conduct negatively impacts ongoing investigations and judicial processes by creating fear, intimidation, and reluctance amongst witnesses and affected parties to cooperate freely with law enforcement agencies. This does not only hamper the ability of the police to effectively execute their constitutional mandate, but also compromises the fairness and the effectiveness of the broader criminal justice system. Paragraph 55. The actions of the applicant have also attracted significant public attention and scrutiny, which has the potential to erode public trust and confidence in law enforcement institutions, prosecutorial processes, and the judiciary. Public confidence in the criminal justice system is fundamental to maintaining law and order, and any conduct perceived to undermine the system brings the administration of justice into disrepute. Paragraph 56. Under these circumstances, it is submitted that the conduct of the accused poses a serious threat to the proper functioning, credibility, and integrity of the justice system and cannot be viewed lightly. Previous convictions, pending matters, and/or personal circumstances. Fadiel Adams, the applicant. Residential address confirmed at 24 Wembley Drive, Colorado, Mitchell's Plain, Cape Town. Address of employment and name of employer, Member of Parliament in the Republic of South Africa. He is a South African citizen. He is married with 4 children. Previous travel or residence outside the Republic of South Africa is unknown. Relative residence outside of the Republic of South Africa is unknown. Assets outside the Republic of South Africa is also unknown. Pending cases, no pending cases. Previous cases. Applicant was previously arrested and charged with 2 cases of criminal injury as per case Cape Town Central Case 311 of 3 of 2024 and Bishop Lavis Case 175 of 8 of 2019. See attached SAPS 69 profile. 1 case, Cape Town Central Case 311, 3 of 2024, was ordered by the court to unconditionally issue a public apology to the complainant and was ordered to undertake a program on racial sensitivity training at his own expense. The other case, Bishop Lavis Case 175 of 8 of 2019, was declined to prosecute and referred to civil court. This affidavit, Your Worship, was signed by the deponent and commissioned by the Commissioner of Oath on the 13th day of May 2026. With the leave of the court, before I can ask to have the affidavit formally marked as part of the exhibit, if I may please, Your Worship, read just a few of these attachments that are compiled in the affidavit of the investigating officer, specifically SM5, a portion of just one. It's the last page, Your Worship, of the affidavit, the attachment.
Yes, thank you.
It reads as follows, Your Worship. Lock me up. I won't apologize to that poos. The Equality Court finds that I've discriminated against the city manager who's discriminated against us. Fuck the court. That is all I wish to read from the annexures. The affidavit, Your Worship, may please be marked as part of the exhibits.
Thank you. I'll mark it as Exhibit B for the record.
Is it please the court?
Thank you. Anything else, Mr. Mabul, from the state side?
So please the court, Your Worship, there's nothing else. That's the state's case.
Thank you. Mr. Gengai?
Thank you, Your Worship. I have prepared an affidavit for the accused and the applicant in this matter. There are, however, several things that have been raised that we need to address. May I suggest that we take the stand down. I will amend the affidavit accordingly, and then we will deal with it.
All right. I see the time now that is slow. It's gone 1:45. Perhaps could we resume at 1:45? Would that be suitable?
1:45 is suitable, Your Worship.
Suitable, Your Worship.
Thank you. Then we'll take the lunch adjournment and resume at 1:45. Thank you.
May it please the court. Perhaps before I proceed to the actual supplementary affidavit, I wish to draw the attention of the court to paragraphs 46 and 47 of the first affidavit, which was read into the record. The court would recall that there was reference to a request made by the applicant to get statements from a witness. We have made reference of a WhatsApp, and there's a statement which is attached as SM6.
Yes.
I have noticed that you do not have that attached just behind that SM6. I beg leave to the court that the SM6 to reflect and be part of that SM6. It won't be marked separately, but it forms part of SM6, if it is in order with the court.
Mr. Genga, have you had an opportunity to see the documents that the state is referring to?
Your Worship, I've had a quick sight of it. My instructing attorney will continue to deal with it as we go along, but I have no objection to it being included in the act.
Right. Thank you. Then we'll include it in the affidavit after SM6.
May it please the court. I now proceed with the leave of the court to read the supplementary affidavit into the record.
Thank you.
I will just not bore the court with the citations and just proceed straight to the affidavit.
Thank you. I appreciate it.
Court pleases, I, the undersigned, Sandile Henwell Mavuka, hereby declares under oath as follows. Further to my affidavit before this honorable court, admitted as Exhibit B, I wish to state further that some of the claims made by the applicant as far as the generals of the South African Police Services are concerned have been investigated and were found to be baseless. The applicant claims in his video clips rather, that were played in this honorable court, that General Dumisani Khumalo was behind the killings of Sindiso Magaqa, and as such he has interviewed the hitman Sindiso Magaqa for the purposes of exposing this fact. 3, I went to check and have a look at the statement he obtained from Sindiso Magaqa on the 24th of January 2025, and therein I could not identify any mention of Lieutenant General Dumisani Khumalo as being behind the killing of Sindiso Magaqa. See attached statement marked SM7 and 8 respectively. Paragraph 4, records will reflect that Lieutenant General Dumisani Khumalo in the year 2017, when Mr. Sindiso Magaqa was shot and killed, he was reporting under SAPS Division, Operations Response Services, and not crime intelligence, as portrayed by the applicant. Only during the year 2018, when the Political Killings Task Team was established, General Dumisani Khumalo led this team and ensured that the hit orderers, hitmen, coordinators, spotters, murder weapons, as well as other exhibits were secured for the successful prosecution of this matter, and that is public record. It was only in December 2022 when General Dumisani Khumalo was appointed to head Crime Intelligence Division. I therefore plead with this honorable court to disregard all the utterances and claims made by the applicant, since they are baseless, defamatory, and lack any reasoning, either in fact or in law. I know and understand the contents of this statement. I have no objection to taking the prescribed oath, and he considers the oath prescribed to be binding on his conscience. It was properly commissioned. I will not proceed to read into the record the SM7 and SM8. Safe to say that they form part of the record.
Thank
May
you.
it please the court.
Thank you. Mr. Gengai, do you have a copy of the supplementary affidavit?
It was given to me shortly before we reconvened, Your Worship.
All right, thank you. Then I'll mark this as Exhibit C for the record.
May it please the court.
Thank you.
I now safely say that is the case for the state.
Thank you. Thank you.
Thank you, Worship. I'm indebted to the court for the indulgence. We have managed to prepare a supplementary affidavit as well for the applicant.
Thank you.
And I will read both the affidavit and supplementary as we proceed.
Thank you.
Your Worship, I start with the affidavit, and this is the affidavit of Fadiel Adams in support of the application for bail. He says, I, the undersigned Fadiel Adams, identity number 760614523708 do hereby make oath and state the following. The facts deposed to herein, unless the context indicates otherwise, are within my own personal knowledge and are to the best of my knowledge and belief both true and correct. Where submissions of a legal nature are made herein, I do so on the advice of my legal representatives, which advice I accept as correct. I, Fadiel Adams, an adult male South African citizen, born on 14 June 1976, bearing the identity number which was mentioned before, a copy of my identity document is attached hereto and marked as Annexure FA1. I am a sitting member of Parliament and the President of the Cape Coloured Congress, and I appear before this Honourable Court as the applicant in a bail application arising from my arrest on 5 May 2026. The chronology and background to the address, I'm now reading paragraph 4. I set out here under a chronological account of the events that preceded and attended my arrest. The sequence is directly material to the present application and demonstrates, I respectfully submit, both my consistent good faith engagement with the criminal justice process and the serious irregularities that attended the manner of my arrest. On 9th April 2026, paragraph 5, my erstwhile attorneys of record, Mr. Shahid Shruda, addressed written correspondence to the relevant authorities to inquire whether a warrant of arrest had been issued against me. That letter expressly conveyed my willingness to comply with the legal process and my unequivocal intention to surrender myself at the nearest police station upon request. This correspondence is a clear and documented demonstration of my good faith. A copy hereof has been attached hereto and marked as Annexure FA2. Paragraph 6. Unbeknown to me and my attorneys at the time, a J50 warrant of arrest had in fact been issued on 30th April 2026, some 3 weeks after my attorneys had formally sought to ascertain the position. I was not informed of this, nor was the warrant served upon me or brought to my attorney's attention at that stage. It was only upon my arrest on the 5th of May 2026 that I perused the warrant for the first time. A copy of the warrant is attached here to mark FA3. Paragraph 7. On 2 May 2026, at approximately 4 a.m., it would be, a group of individuals purporting to be police officers attended at a property previously owned by me, situated at 66 Korenhof Street, Westreach, Mitchells Plain, Western Cape. Mrs. Brown, the person who had purchased the property from me and who is the current occupant, was present. All of the individuals were wearing masks and refused to disclose their identities to the police station from which they operated. They forcibly broke the padlock of the gate to gain entry, produced neither a search warrant nor any other formal documentation, and during the course of their attendance assaulted Mrs. Brown's minor son. They departed without leaving any contact details. Later that same day, Mrs. Brown reported the incident to the Mitchell's Plain police station, and a case was duly registered under Mitchell's Plain CAS 65 of 5/2026. The conduct of these individuals, the forced entry, the concealment of identity, the absence of any warrant or documentation, and the assault on a minor was deeply alarming and compelled me to take precautionary steps to verify whether any warrant against me had lawfully been issued. Have we given the match to the copy? Your Worship, I apologize. I have a copy for Your Worship if you wish to follow. I apologize, Your Worship. The supplementary affidavit is there as well.
Thank you.
I'm at paragraph 9, Your Worship, which is on page 4.
Thank you. You can continue.
On 3 May 2026, Lieutenant General Nhlanhla Mkhwanazi, Provincial Commissioner of KwaZulu-Natal, forwarded the correspondence of my attorneys to Major General Anthony Gopal. The email is significant as it reveals the confused and contradictory state of the authorities' own knowledge regarding the existence of the warrant. In that email, Lieutenant General Mkhwanazi stated the following: in receiving this email, I made inquiries with the prosecutor who is handling the case, and he informed me that there was no warrant of arrest issued. As you know, that I have been assigned to a task at national level, therefore I am not fully aware about the status of investigation work of the PKTT in KZN. However, I learned that there is a warrant of arrest issued. Therefore, I am sharing this email in order for you to advise the team to make contact with his lawyer in order to secure his presence at the police station for processing. Quotes, and that is quoted directly from the email. Paragraph 9.2, a copy of this email is attached hereto and marked Annexure FA4. I respectfully submit that the email demonstrates material uncertainty and lack of coordination within the relevant prosecutorial and investigative structures regarding whether the warrant of arrest had in fact been issued. According to the email, Lieutenant General Mkhwanazi first made inquiries with the prosecutor handling the matter and was informed that no warrant had been issued. He thereafter learned that a warrant had in fact been issued and accordingly requested that the team make contact with my legal representative in order to secure my attendance at the police station for processing. This uncertainty, viewed together with the events of 2nd May 2026, caused me and my legal representatives genuine concern and led to the urgent application at the High Court. Paragraph 10. Confronted with these contradictions and mindful of the well-documented acrimonious history between myself and the political killings task team, I instructed my erstwhile attorneys to launch an urgent application in the Western Cape High Court. The purpose of that application was not to evade the criminal process, but to compel the authorities to disclose the warrant and its supporting documentation so as to enable me to assess the legality and validity of any proposed arrest. An urgent application was duly brought under Western Cape High Court case number 2026-09992. The respondent cited where the Acting Minister of Police, Lieutenant General Nhlanhla Mkhwanazi in his capacity as Provincial Commissioner of KwaZulu-Natal, and Lieutenant Colonel Majila, Commander of the PKTT. On 5 May 2026, Justice Njokweni granted an order in the Western Cape High Court directing the second and third respondents to furnish my erstwhile attorneys within 24 hours with a copy of the J50 warrant of arrest, together with all supporting documentation submitted in support of the warrant application, subject to the proviso that personal information such as identities of informants and specific addresses could be redacted. A copy of the order is attached hereto and marked Annexure FA5. In paragraph 12, on the very same day and before the respondents had complied or even begun to comply with the court order, I was arrested at my parliamentary residence in Pelican Park. I was conveyed to Cape Town Central Police Station, where I was served with the SAP 14A Notice of Rights attached hereto and marked Annexure FA6. It was only at this point that I was shown the J50 warrant of arrest for the first time. I record too that the address reflected on the warrant documentation is 33 Annette Drive, Montrose Park, Mitchell's Plain, a property at which I have not resided for approximately 15 years. This further demonstrates the unreliability of the investigating officer's submissions regarding my address. I respectfully submit that the failure by the respondents to comply with the High Court order of Justice Njokweni prior to effecting my arrest is a matter of serious constitutional and legal concern. It is directly relevant to this Honourable Court's assessment of the bona fides of the investigating authorities and consequently to the question of whether the interests of justice required by my continued detention. I further draw this Honourable Court's attention to the supporting documentation placed before the magistrate in support of the warrant application, in which the investigating officer stated that I could not be arrested in the normal way because more people will know about it and might alert him. The investigating officer's stated basis for classifying me as a flight risk was threefold. One, that I have a number of addresses. Two, that those addresses are spread across distant provinces, making me difficult to locate. And three, that he was uncertain whether I had remained a member of parliament. Each of these contentions is factually incorrect and without evidential foundation. I address them comprehensively in the flight risk assessment below. Residential address, paragraph 15. My primary residential address is 24 Wembley Drive, London Village, Mitchell's Plain, Western Cape. This property was purchased by my wife and has been our family home since 27 February 2026, approximately 3 months ago. Prior to this, our family resided at 66 Korenhof Street, Westridge, Mitchell's Plain. The current property is bonded. A copy of the title deed registration is attached hereto and marked as Annexure FA7. My alternative address is Unit 23, ERF 1219, Buck Road, Pelican Park, Cape Town, Western Cape, being my parliamentary resident allocated to me as a member of parliament. Confirmation of my parliamentary village allocation is attached here to marked Annexure FA8. Paragraph 17, crucially, it was at this parliamentary address that I was arrested, which is itself compelling evidence that I am neither a flight risk nor difficult to locate. Prior to my arrest, I participated in multiple media briefings in which I publicly declared my willingness to surrender myself. I cooperated fully upon arrest, walking voluntarily with the arresting officers uncuffed to the police vehicle. Paragraph 18. Furthermore, my legal representatives have made contact with the commander of the PKTT, Colonel Majila, and furnished her with an affidavit deposed to by my wife confirming my residential address. That affidavit is attached here to marked Annexure FA9. His personal circumstances and marital status. I respectfully submit that the suggestion that I have a number of addresses and I am therefore a flight risk is contradicted by the documentary record. The only two addresses associated with me are my family home and my parliamentary residence, both within the Republic, both known to the authorities, and both disclosed on the warrant documentation J15 annexed hereto. Furthermore, I have never owned, let, or lived out of Cape Town. I am married to Letitia Nelline Adams. We were first married in terms of civil rights approximately 12 years ago, thereafter divorced and subsequently remarried in terms of the Muslim rights on 11 April 2023. We have 2 children together, a daughter aged 18, currently in grade 12, and a son aged 16. In addition, 2 of my wife's sister's children, aged 17, currently in grade 11, and aged 15, currently in grade 9, have been residing with us for approximately the past month. All the children are South African citizens and are enrolled in full-time schooling in the Western Cape. My eldest daughter is currently in grade 12, her final year of secondary schooling, and academically the most consequential year of her life. My arrest has caused her immeasurable distress at a critical juncture. My continued detention will only deepen this harm. I am the primary financial provider for my household. My income funds school fees, medical aid contributions, daily living expenses, and all essential necessities for my family's welfare. My absence has immediate and devastating financial consequences for my wife and children. My mother, Rabia Adams, is 83 years old. She is financially dependent on me and relies on me to ensure the regular provision of her prescribed medication and the management of her medical and financial affairs. My continued detention has already materially and adversely impacted her mental and physical health. My extended family, including siblings, resides within the Western Cape. I am deeply embedded in my community and serve as a stabilizing and supportive presence therein. There is no credible basis upon which it could be suggested that I would abandon these ties. Employment and political career, paragraph 26. Prior to my involvement in politics, I was engaged in various forms of employment, including working as a tiler and a plumber in about 2018. I became active in political affairs. In 2018, I co-founded the organization known as Gatval Capetonian, an organization established to address inadequate service delivery, the impact of certain economic empowerment policies, and the scourge of crime in the Cape Flats. In 2020, I founded the Cape Coloured Congress and served as its president in the 2021 South African municipal elections. I was duly elected as a councillor to the city of Cape Town. The Cape Coloured Congress has secured representation at the National Assembly, holding 2 seats in Parliament. I am a duly elected member of Parliament and currently serve on the Portfolio Committee on Police Oversight since 2024. In this capacity, I exercise direct oversight of policing matters at the national level. I earn a monthly remuneration of approximately 140,000 Rand. I have a fixed, verifiable and permanent income and no financial incentive to flee. I suffer from arthritis in my right shoulder, for which I am currently taking prescribed medication, Artrexon, and in respect of which I am in the process of scheduling a surgical procedure. The transport conditions in which I was subjected to during my extradition have exacerbated this condition and may necessitate the expedition of the planned surgery. I am further experiencing severe and ongoing psychological stress, which has materially impacted on my general well-being. This court is respectfully asked to take judicial notice of the well-documented conditions prevailing in South African correction facilities, which are overcrowded, chronically under-resourced, and not conducive to effective management of either physical or mental health conditions. Continued detention would significantly and adversely affect my health and my recovery prospects. Assets, paragraph 35. The immovable property situated at 24 Wembley Drive, London Village, Mitchell Plains, Western Cape, is registered in my wife's name. The bond obligations in respect of this property are met by my wife from the spousal benefit she receives from me. I do not hold any movable property or other significant assets in my own name. My ongoing financial obligations to my wife and family within the Republic, including the funding of the bond repayments, constitute substantial and tangible ties to this jurisdiction. Travel documentation. I hold a South African passport. I record for this Honourable Court's express consideration that I have never travelled abroad. My passport bears no entry or exit stamps of any description and reflects no international travel whatsoever. This fact conclusively and demonstrably negates any suggestion that I possess the means, the connections, or the inclination to flee the Republic. I am prepared to surrender it unconditionally to the investigating officer or to deposit it with the clerk of court forthwith my release. The charges and the applicant's response thereto. I am informed that I face the following charges, to which I plead not guilty. 2 counts of defeating or obstructing the course of justice in contravention of common law and 3 counts of fraud in contravention of the common law. The state alleges in substance that on about 2 November 2024 and 24 January 2025, I attended Westville Prison Correctional Centre and conducted separate interviews with 2 awaiting trial inmates, one of whom was in custody in connection with the Sindiso Magaqa murder matter, and the other in custody in respect of a partly heard matter. The state further alleges that I misrepresented myself to officials of the South African Police Service, the eThekwini Metropolitan Police, and the Westville Prison or Correctional Services as being present in an official capacity. That on the strength of this alleged misrepresentation, official escorts were arranged for myself from King Shaka International Airport to the correctional facility and back. That I engaged with the inmates without the authorization of the investigating team or the legal representation of the inmates, and that I was not officially mandated by Parliament to conduct these visits. I deny each and every allegation made against me in the strongest possible terms and plead not guilty to all 5 counts. Without derogating from the generality of this denial, I record the following in brief. As a Member of Parliament serving on the Portfolio Committee on Public Oversight, my engagement with matters of a policing and correctional services nature falls squarely within the purview of my parliamentary functions. The visits to Westville Correctional Services were conducted in this context, and I did not misrepresent my identity or my status. I attended in my capacity as a Member of Parliament and was received as such. The state's allegation that I was not officially mandated by Parliament to conduct these visits fundamentally mischaracterizes the nature and the scope of the parliamentary oversight functions. Members of Parliament are not required to obtain specific mandate for each and every engagement conducted in pursuance of their oversight responsibilities. The suggestion to the contrary reflects a misunderstanding of the constitutional and legislative framework governing parliamentary conduct. The charges of fraud are denied. No false representations were made with the intention to defraud, and no person suffered any prejudice as a result of my conduct. The elements of the offence of fraud are not satisfied on any version of the facts. I have been afforded no proper opportunity to consult my legal representatives in preparation of a comprehensive response to the charge. My right to a fair trial, enshrined in Section 35(3) of the Constitution, demands that I be released on bail so as to enable a meaningful legal consultation and a proper preparation of my defense. Paragraph 41. I am advised and respectfully submit that the charges preferred against me properly fall within the ambit of Schedule 1 of the Criminal Procedure Act 51 of 1977 and do not constitute Schedule 5 offences. The charges of fraud and defeating or obstructing the course of justice as formulated on the facts alleged by the state do not meet the threshold required for the classification as Schedule 5 offences, and I accordingly challenge the state's characterization. Your Worship, I believe that that paragraph has been overtaken by the events as they've unfolded. In the alternative, and without conceding to the correctness of Schedule 5 classification, should this Honourable Court find that the charges do not fall within Schedule 5 and that Section 60(11)(b) of the Criminal Procedure Act applies, I recognize that the onus rests on me to satisfy, and again that paragraph, Your Worship, has been overtaken by the events as we've proceeded. I respectfully submit that this application falls to be determined in terms of Section 64A to E, read with Section 60, brackets 9, 62, 63, and 68 of the Criminal Procedure Act. Section 60, brackets 1 of the Criminal Procedure Act affirms that an accused person is entitled to release on bail at any stage preceding sentence if the court is satisfied that the interests of justice so permit. Section 35(1)(f) of the Constitution of the Republic of South Africa, 1996, further entrenches every arrested person's right to be released from detention if the interests of justice permit, subject to reasonable conditions. The presumption of innocence is a foundational constitutional imperative which must inform every aspect of this court's analysis. I respectfully submit that the interests of justice emphatically require my release on bail, and that given the totality of the circumstances, my continued detention is neither warranted nor proportionate. At Section 60, brackets 4, brackets A, the likelihood of endangering public safety or committing Schedule 1 offences. The charges presently facing me are non-violent in nature. There is no suggestion that my alleged conduct involved violence, the use of weapons, or any threat to the physical presence of any person. I have no previous convictions, no outstanding warrants, no pending matters involving violence or the threat of violence. Upon my arrest, I offered no resistance whatsoever and cooperated fully with the members of the South African Police Service effecting my arrest. The state cannot establish on a balance of probabilities that there is any likelihood that I will endanger public safety or commit a Schedule 1 offence if released on bail. This factor weighs decisively in my favour. I now proceed to Section 60, brackets 4, brackets B, the likelihood of evading trial or flight risk. I categorically and unreservedly deny that I constitute being a flight risk. I address the specific basis advanced by the investigating officer in support of this allegation seriatim. It was submitted that I have a number of addresses in different provinces, and I have demonstrated above I have precisely 2 addresses, my family home and my parliamentary address, both within Western Cape, both known and disclosed to the authorities, and both permanent. This submission is factually without foundation. I confirm that I am a current, active member of Parliament, serving on the Portfolio Committee on Police Oversight. This is a matter of public record. My parliamentary status renders me eminently traceable and accountable. I am the president of the National Cape Coloured Congress, which represents thousands of South African citizens and holds 2 seats in the National Assembly. My political party, my family, my constituents, and my community all have a profound stake in my remaining in this country and standing trial. My wife and our 2 kids are South African citizens residing in Cape Town. My elderly mother, aged 83, is financially and medically dependent on me. These ties are not merely nominal. They are the very fabric of my being. There's a word missing in that paragraph, Your Worship.
Thank you.
I have at all times demonstrated an intention to engage with the criminal justice system in accordance with the rule of law. The steps taken by my attorneys to verify the validity of the warrant were taken in good faith and in the exercise of my constitutional rights, not a flight risk from the process. I did not flee, conceal myself, or seek to evade the authorities. As is more fully set out in the section on my criminal history below, I have a demonstrably consistent record of attending court appearances without fail and without breach of any court order or condition. Paragraph 60, brackets 4, brackets C, the likelihood of influencing witnesses or tampering with evidence. I unequivocally deny any intention to interfere with any witnesses or tamper with evidence. This allegation is wholly unsupported by on the evidentiary basis. I am fully cognizant of the consequences of breaching bail conditions. I appreciate that any interference with witnesses or the administration of justice will result in the immediate revocation of my bail. This awareness, combined with my genuine respect for the criminal justice process, provides ample assurance that no such conduct will occur. Suitable bail conditions, including restrictions on communication with potential witnesses, can be tailored to address any residual concern that the state may have in this regard. In this respect, I specifically record the following. I am aware that the state may express concern arising from the nature of the allegations and, in particular, from the fact that the charges relate to interactions with people detained in correctional facilities and matters presently subject to criminal investigation and prosecution. I respectfully submit, however, that there is no factual basis to conclude that my release on bail will result in interference with witnesses, inmates, or officials or the investigation process. I expressly undertake that if released on bail, I will not directly or indirectly contact any state witnesses connected with this matter, save through lawful processes and, where necessary, through my legal representatives. I further undertake not to communicate with any inmate who may be connected to the subject matter of the charges, nor with any correctional services officials, police officials, or any other person identified by the investigating officer as a potential witness in these proceedings, save through the lawful channels and in accordance with any conditions imposed by this honorable court. Without derogating from my denial of the allegations against me, my position regarding the lawful scope of my parliamentary functions, I undertake that pending the finalization of this matter, I will not engage in any contact or interaction with any inmate, correctional service official, or other person connected to the subject matter of the charges, save through the lawful processes in accordance with any conditions imposed by this court. I respectfully submit that any residual concern the state may have regarding the possible interference can adequately and appropriately be addressed through carefully tailored bail conditions. I expressly record my willingness to abide by any reasonable condition imposed by this court, directed at safeguarding the integrity of the investigation or the administration of justice. I have acted openly and through lawful channels. I cooperated fully with the authorities upon arrest, have not sought to conceal my whereabouts, and remain committed to participating in the legal process and complying strictly with all bail conditions imposed by this honorable court. In terms of section 60, brackets 4, brackets D of the Criminal Procedure Act, the likelihood of undermining or jeopardizing the objectives of the criminal justice system. There is no evidence, whether direct or circumstantial, that my release on bail will undermine or jeopardize the proper functioning of the criminal justice system. I have consistently demonstrated deference to legal processes, and my past conduct is the most reliable indicator of my future behavior. On the contrary, I submit that the manner in which my arrest was concluded, including the failure to comply with the High Court order of Justice Njokweni, the clandestine approach adopted by the PKTT, The use of my former addresses on a warrant documentation and the treatment of Mrs. Brown's family raises serious concern about the conduct of the investigating officer and the integrity of the process itself. As to add paragraph 60, brackets 4, brackets E, the likelihood of disturbing the public order or undermining the public peace. My release on bail will not disturb the public order or occasion public unrest. There is no factual or evidentiary basis upon which the state can assert otherwise. I respectfully submit that there is no factual basis upon which it can reasonably be concluded that my release on bail, subject to appropriate conditions, would disturb the public order or undermine public peace. Prejudice likely to be suffered by the applicant. The prejudice that I will suffer if bail is denied is substantial, multidimensional, and in several respects irreversible. As a sitting member of Parliament, my continued detention directly impairs my ability to perform my constitutional and legislative duties, including participation in parliamentary sittings, committee work, and the representation of my constituents. This constitutes a direct infringement of the democratic mandate entrusted to me. The financial prejudice to my family has been addressed above. The harm to my daughter in a metric year, to my elderly and ailing mother, my minor children, and foster children is real, pressing, and not capable of subsequent repair. My shoulder condition requires surgical intervention as a matter of urgency. Detention in a correctional service will impede access, and appropriate medical care will cause my condition to deteriorate in the absence of medical care. The preparation of my defense in these proceedings is a constitutionally protected right. My continued incarceration will severely hamper meaningful consultation with my legal team, thereby prejudicing my right to a fair trial. In terms of section 60 brackets 9, the balancing of interests, section 60 brackets 9 of the Criminal Procedure Act requires this honorable court to weigh the interests of justice, including the state's interest in ensuring that I stand trial, against my right to personal freedom and the presumption of innocence to which I am constitutionally entitled as an accused person who has not been convicted of any offense yet. The state's interest is properly and adequately served by appropriate bail conditions, including the surrender of my passport, reporting conditions, prohibition on contact with witnesses, and any other conditions this honorable court deems appropriate. I am a husband, father, brother, son, community leader, and elected representative of the people of South Africa. I am deeply and irrevocably anchored to this country. The imposition of suitable bail conditions will adequately protect the administration of justice while vindicating my constitutional rights. I have no previous convictions, no outstanding warrants of arrest, and no protection orders against me. I was previously charged before Bishop Lavis Magistrates Court under case number 175 of 8/2019. The charge was criminal injuria, intimidation, and assault arising from social media posts. The state elected to decline to prosecute this matter, and it was formally withdrawn on 12 September 2019. A copy of the relevant documentation is attached hereto and marked Annexure FA10. A further matter was registered under Cape Town Central CAS 311 of 3/2024, being court case number 13/0345/2025 for criminal injuria. In that matter, I voluntarily presented myself to the Cape Town Police, was issued with the SAP 496, that is a warning to appear, and complied diligently with every court appearance. The matter was subsequently withdrawn on 19 February 2026. Copies of the SAPS 496 and the endorsed charge sheet are attached hereto and marked Annexure FA11 and FA12 respectively. I respectively draw this court's attention to the J15 charge sheet, which reflects my address as 66 Corenhoff Street, Westreach, confirming that I have not maintained multiple secretive addresses and directly undermining the investigating officer's assertions that I am a flightless by virtue of having numerous undisclosed addresses. In neither of the foregoing matters did I fail to appear in court. breach my bail condition, or in any way demonstrate disrespect or non-compliance for the criminal justice process. The state's own assessment and admission against interest. I respectfully submit that the objective circumstances surrounding my arrest, including the communications exchanged prior thereto, demonstrate that the authorities were aware of my willingness to cooperate with the criminal justice process and to make myself available if required. I respectfully submit that it is consistent with my conduct throughout and inconsistent with any intention to evade the process of the court. I further respectfully submit, notwithstanding the concerns raised by my legal representatives regarding the manner in which the process unfolded. I have acted openly and through lawful channels at all material times. My attorneys made inquiries concerning the existence of a warrant of arrest, conveyed my willingness to present myself to the authorities, and sought clarity regarding the applicable process. I have never concealed my whereabouts, attempted to leave the Republic, or acted in a manner calculated to frustrate the investigation or administration of justice. I respectfully submit that the totality of my personal, professional, and financial and familial circumstances, read together with my established history of cooperation with legal processes and court attendance, demonstrates that the interests of justice permit my release on appropriate bail conditions pending the finalization of this matter. In conclusion, having regard to all of the foregoing, I respectfully submit that I do not pose a danger to the public or any individual, that I am not a flight risk as demonstrated by my settled personal circumstances, my strong community and family ties, my parliamentary status, and my consistent history of court attendance. There is no reasonable likelihood that I will interfere with the witnesses or tamper with evidence. My release on bail will not undermine the criminal justice system or disturb the public order. I have and will continue to cooperate fully with the criminal justice process, and the interests of justice unambiguously favor my release on bail subject to appropriate conditions. I accordingly pray that this Honorable Court grant me the following relief: that I be released on bail in the amount of 20,000 rand, which sum is available and ready to be deposited with the court forthwith; that I surrender my passport to the investigating officer or at the Mitchell's Plain or Grassy Park police station as directed by this Honorable Court; that I report to the Mitchell's Plain or Grassy Park police station as directed by this Honorable Court; that I provide the Honorable Court and the investigating officer with my residential address and undertake to notify them of any change of address, and that further and or alternative conditions imposed by the Honorable Court, that the Honorable Court may deem appropriate in the circumstances. I submit that the conditions sought above individually and collectively adequately safeguard the administration of justice, while property and proportionately vindicating my constitutionally entrenched rights to freedom and presumption of innocence. It is signed and signed by the accused. I will not go into the annexes, but they are attached. May it be marked Exhibit D in these proceedings. Your Worship, my client...
You made mention of the supplementary affidavit.
I will proceed to read it now.
Yes.
My instructing attorney tells me that the client wishes to give him an instruction.
Yes, sir.
Your Worship, the supplementary affidavit, it is handwritten, and I apologize for that. We did it during the lunch adjournment. I, the undersigned Fadiel Adams, hereby make oath and say, I am the applicant in this matter under case F245 of 2026. I have deposed to a previous affidavit in support of my application to be admitted to bail. On the morning of May 13, 2026, being the morning of my bail application, I received the affidavit deposed to by Detective Sergeant Mavula, the investigating officer in my matter. There are certain essential allegations that he makes in such affidavit that require my reply. In reply to paragraph 34, I deny refusing to cooperate with Colonel Mashede and admit declining his offer to drive me to the police station, as I was satisfied that there was a warrant and they were happy to, and I was happy to hand myself over. My surrender can be confirmed by both SABC
members.
By SABC members and the correct footnote. I apologize, Your Worship. At paragraph 38 and 39, I did not disregard a court order. In fact, the case was withdrawn as I proved to the attorneys that I had complied with the court order. At annexure, the SMS, this annexure is undated and relates to a time when I was an activist and not a member
Sorry,
of parliament.
Mr. Gengai. Perhaps you should have had this typed out, because I think even you are now reading incorrect things. It's SM5,
I
not
apologize,
SMS.
Your Worship, it is not my handwriting.
Yes.
But yes, it is indeed SM5. We will have it typed out. I'm just reading this record as it is. This annexure is undated and relates to a time when I was an activist and not a member of parliament. At paragraph 46, I was unaware of the identity of the witness in this matter and had been in police custody from the time that the identity of the witness was made known. At paragraph 48, the information that was in my possession was handed to me by the SAPS. At paragraph 50, I denied this and reiterate that I had cooperated fully with the court order. And at paragraph 55, it is my responsibility as a member of parliament to ensure public attention and scrutiny to issues that prevail and require investigation. My actions are not premised on any other motive of self-gain, but purely to ensure transparency and accountability, and it is signed by the accused and commission. May it be marked and make sure it will be Exhibit T.
Thank you. Mr. Adams, did you hear the affidavit that was read out, was prepared on your behalf and read into the record?
Yes, I did, Your Honor.
Do you understand what is contained in this affidavit?
Yes, I do, Your Honor.
You confirm that the contents of this affidavit is true and correct?
Yes, it is, Your Honor.
Are you aware, Mr. Adams, that whatever is contained in this affidavit can and may be used as evidence in any subsequent proceedings relating to this matter?
I do, Your Honor.
And do you confirm that in signing this affidavit, you confirmed that the contents are true and correct?
True and correct, Your Honor.
Thank you. Now, further to that, a supplementary affidavit, which is handwritten, was also read into the record. Are you aware of the contents of that affidavit?
Yes, Your Honor.
You confirm that the contents of this supplementary affidavit are true and correct?
100%, Your Honor.
You're also aware, sir, that whatever is contained in the supplementary affidavit can and may be used as evidence in any subsequent proceedings relating to this
Yes, I do,
matter?
Your Honor.
You confirm that in signing the affidavit, you are admitting that the contents thereof is true and correct?
Yes, Your Honor.
Thank you. So the first affidavit I will mark as Exhibit D1 and the supplementary as Exhibit D2. Thank you. Mr. Gengai, anything further from the defense?
That's the applicant's case in the proceeding.
Thank you. Mr. Martin?
May it please the court. Unfortunately, the supplementary affidavit, I think we've tried to, we do not have the copy of it. And there is one aspect that we wish perhaps to reply to, particularly raised in this supplementary affidavit. It shouldn't take us.
You're going to refer me to the authorities that say you can reply?
We beg leave to the court, or unless maybe we can deal with it in arguments, if
I think
needs
that
be.
would be more appropriate.
Please, the court.
Are you ready to address Mr. Martin?
Can you give us just 5 minutes to 10, and then we address the court?
Mr. Gengai?
I am ready, Your Worship, to
All right. Then the state has asked for some time. I will give you 10 minutes and I will be back. Thank you. So, please ask Mr. Franca. I don't know where's Ntoli. I see Franca.
Yeah.
To come and see me, please, because I see the attorney, Ms. Kuzwayo, as well. Ask her to come through as well. But I see them there. I just want to ask. Thank you.
No.
I took both copies out to the, sorry.
having to discuss how to craft a judgment, rather an argument can take more than that. However, we try. Your Worship, I just want to start with paragraph 9 of Exhibit D. This comes on the wake of a letter which is attached on Exhibit B as SM email 1. If I can go to the 8th page of SM email 1, Your Worship. This is a letter that was written by Attorney Shahid Schroeder on the 9th of April 2026 to the Minister or the Acting Minister of Police, which is referenced on the applicant's affidavit. We need to understand the timelines and in the process try to remove the confusion, self-made confusion by the applicant. An email is sent by Mr. Schroeder in the beginning of April 2026, whereby the applicant is saying, should the PKTT have a J50 on my name, let me know, I'll hand over myself. Well said, nothing wrong with that. Now, he says in 9.1, from paragraph 9, there was a confusion. He didn't trust this warrant. He had to rush to court to go to court order because there was confusion. And it appears, Your Worship, the confusion is made by an email that is sent by the office of Lieutenant General Mkwanazi on Sunday, the 3rd of May, which is attached as FA4. Can we read FA4 properly so that we show the self-imposed confusion by the applicant? Morning, General. I've heard that you are looking for Mr. Adams, PM, and thought that I must share this letter, which was emailed to the Acting Minister of Police, and the copy was sent to me in April 2026. It starts like that. But the applicant chose not to put this part, or this portion of the email, on paragraph 9.1, because the next paragraph talks to the previous paragraph. It says, in receiving this email, which email? The email that was sent was where it was copied when it was sent to the Minister of Police. That is the email he's talking to. In receiving this email, I made inquiries. The email would have been sent on the 9th of April 2026. Then he made inquiries. He was copied, as he says, on the first paragraph. Major General, which letter was emailed to Acting Minister and copy was sent to me in April 2026. The confusion is saying this he received on the 3rd of May. That's not true. When the minister was sent an email by the applicant's attorney, the Lieutenant General Mkhonazi was copied on it. And upon receiving that email, he made inquiries to the team of the prosecutors about this warrant. And he was informed, properly so, and truly so, that there was no warrant at the time. Because the warrant was only signed on the last day of April 2026. It's attached. Who's confused? Self-made confusion. Let us remove the first paragraph so that the context to the court must not portray the true reflection of what transpired. Therefore, here's paragraph 9 up to paragraph 14. It's a self-made confusion so as to justify his fugitiveness, which I'm going to argue later on. There was no confusion at all. General Mkhonazi's email is clear. I'm sharing what I was copied on the 9th of April. Therefore, confirming, you can speak to the lawyer because there is this letter. I just wanted to start there, Your Worship. Let us again, in the same breath, understand the court order. Which he says, I had to run to court because there is this confusion. I didn't trust anyone. And they attached the court order. If I can just get the copy thereof, Your Worship. F5, FA5. If the applicant was honest and understood the email as it is portrayed, there was no need for this. FA5. Ex parte application, paragraph 7. That a rule NCC is issued calling upon respondents. The respondents here are the Acting Minister of Police, Lieutenant General Nhlanhla Mkhonazi, Provincial Commissioner of KZN, Lieutenant Colonel Machila, the Deputy Police Commissioner and Acting Crime Intelligence, Detecting rather. I don't know whether that is his post. That a rule NCC is issued calling upon respondents to show cause, if any, within 24 hours of the service of this order, to the above Honorable Court why the respondent should not comply with the order. It is not saying comply. It's saying show a reasonable cause within 24 hours why we should not comply. Now, it is argued that the PKTT did not comply with this order, unconstitutional. All that they needed to do is to go to court and show cause as to why they should not give the J50 to the applicant or his attorneys. Let us understand the perspective of that order. And it does not in any form or manner say, do not arrest this man. It's not saying that. I'm looking at it. Do not arrest. No, there's nothing there. Hence, Your Worship, I'm saying there was absolutely no need for this court order. In the contrary, the applicant was trying to delay as much as possible his arrest. And in the meantime, calculatively made sure that I always do press conferences in the precinct of Parliament because his label's under the impression, PKTT won't touch me there. He said it in the video that we played this morning. That these people are acting unlawfully, they went into the parliamentary precinct and all of that. They were not supposed to be there. I will argue this further when I deal with section 60, subsection 4. Perhaps let us start there. I am not member of parliament, neither are my colleagues or police. We simply interpret and understand the law as it is indicated. Section 60, subsection 4 of the Criminal Procedure Act 51 of 1977 says, the interests of justice do not permit the release from detention and an accused where, 1, or more of the following grounds are established. You only need one, Your Worship, to be established, that you should deny bail. There's a bonus of saying if there's more, you can consider. It is my request to start with 4B and 4C before I go to A and D. These are the words that I used. It's not my words, the legislature's words. Where there is likelihood that the accused, this is now 4B, Your Worship, if the accused, if he or she were released on bail, will, can we underline the next word, will attempt to evade his or her trial. Not that he will, if it can be established that he will attempt to evade his or her trial. What do we have here? We have an applicant who knew as early as Saturday the 1st of May, the 2nd of May. Oh, by the way, the 1st was Workers' Day. The 2nd of May. Hey, there's a warrant for me. He did not stay in his houses. Instead, he went and posted video footages for the whole country to know that he can act better than Harrison Ford. Harrison Ford was a fugitive from justice in the movie. He says, that man, I'm better than him. He told everybody. Not that he will evade. He will attempt to evade justice. I've already mentioned, Your Worship, that he calculated his moves to be always in the parliamentary precinct. That is where he was arrested. He confirms it. Because he's labeling under the impression that they won't touch me there. Is that not an attempt on its own? That is what the law said must be established. The court order, self-made confusion. He goes on the video footages and say, I'm aware they went to this address, they went to this address, they went to my sister's address. Hey, these people, 150 million budget, they can't find me in Cape Town. He says that. We all listened this morning. And then in his bail application, he brings proof of residence. That does not carry his name. I went through that document thinking, Mr. Fadam's name will be there on the deed. Maybe his initial or his, maybe he was a witness, nothing. It's the name of his wife. The wife, he says to this court, I was married to her for some time and we got divorced. We just remarried. But with that history, trust that her address is mine, even though my name is not there. He goes and confirms an address in Parliament. It's not his address, for God's sake. He attaches a letter from the from the Department of Public Works. By virtue of his party having appointed him to represent the party in Parliament, he stays in that address. If the party tomorrow says, Mr. Adams, vamos, he ceases to be a resident in that address. We don't need to prove or establish that he will evade. We can only do so by saying he will attempt to evade. We believe we've established that. Your Worship was addressed about the conduct of the applicant on his first appearance by Mr. Mata as to why the state's attitude changed. There was a reason why we played all these video clips this morning, so that the court cannot hear it from me or from the state as to how Mr. Adams conducts himself. From the horse's mouth, saying all kind of things. Important for this bail application. On one side, the accused, I'm prepared to hand myself. I even wrote a letter to the acting minister. Now the police say, come. As we're taking your invitation, come. He goes there, he goes there, he goes there. Every time he goes, disappears, comes in, disappears, comes in, holds a media briefing and tell everybody how best he can escape the police. Better than Harrison Ford. On Exhibit E, he says, Your Worship, paragraph 3, the last sentence. I was satisfied. I deny refusing to cooperate with Colonel Mashele and admit declining his offer to drive me to the police station. As I was satisfied that there was a warrant and was happy to hand over myself. How was he satisfied? Because the very same PKTT at the gate of the precinct showed Mashele the warrant and he showed it to him. Something that could have been done as early as the 2nd of May. It did not need a court order to execute a warrant, show it to the one who's going to be arrested. You don't post it to the lawyer first and then it goes to somebody else and then no. Show it to the one who's going to be arrested. That's how it's supposed to be effected. He then goes on to say, my surrender can be confirmed. I was looking at Mr. Kangai thinking when I assist with the reading of this word. confirmed by both SAPS members and the camera footage. I request this court to go and look at the footages, maybe from one of the members here. You'll be shocked to see Mr. Mashele actually grabbing the applicant. Grabbing the applicant, let's go. He has invited you to do that. It's not us, it's the applicant. No, go and look at the footage. You'll see that. That is the aspect that we wanted to lead as a supplementary based on what he raised here, Your Worship. But as Mr. Adams has said, you can, then Your Worship can. 4C. We've established one, submit. Now we're giving Your Worship a bonus of saying no, there's more. Where there is likelihood that the accused, if he or she were released on bail, once again, will attempt to influence or intimidate witnesses or to conceal or destroy evidence. Will attempt to influence, will attempt to intimidate, will attempt to conceal, and will attempt to destroy evidence. SM 6. I'm reading from paragraph 2. On Sunday, the 3rd of May, 2026, at about 1500 hours 03, I received a WhatsApp video message from Mr. Fadiel Adams using number blah, blah, blah. Request that he needs to talk to me very urgently. It's not the witness who called Mr. Adams. It's Mr. Adams who initiated the process. He is aware, he has told us on the video, that the police officers of the PKTT are looking for me for having taken a statement from a hitman in prison. He's aware. And therefore, the person who assisted him to do so is a potential witness. He then starts initiating the process. This was followed by a WhatsApp voice call at 15:15, which I did not answer. Then on Monday, another day. We tried on the first one, we go to another day. Can we look at this? The 4th of May at 12:05 at night. This man is not sleeping. 00:05. Mr. Fadiel Adams calls me again on WhatsApp, and I did not answer. We are not establishing him having influence, him making an attempt to influence. Paragraph 3. On the 4th of May 2026, he then called again using WhatsApp. I did not answer. Due to the volumes of calls I was getting from him, at 10:11 I then decided to call him back using my WhatsApp. There was an indication earlier on, Your Worship, from the affidavit of the IO that the attorney, Mr. Schroeder, said the applicant keeps on changing his numbers. This is evidenced by Mr. Adams making a video call to this witness. It's me, don't worry, it's me. This is attached on SM 7. So that he can show faces too. You might not have my number. Don't worry, bro, it's me. There is no at all doubt that he made the call, because it's him on the video to the witness. It's him, whoever touched it. Now, I asked him why he was calling me and warned him that he has to put me into trouble Paragraph 4. There's a warning from this witness. Meneer, stop. Don't call me and put me into trouble. He calls at 21:08. There was no answer. Followed by another call at 21:18. Again, there was no answer. Insisting and insisting to call. And then at 21:30, he sends a WhatsApp saying, asking me to send him my statement I made to the police to his email address. As I said earlier on, Your Worship, there is no way that he can stand here and say, I didn't know who the witness was. Because he has already told the world and the country, you know these people, why they're looking for me? It's because I went to prison and obtained a statement from Mr. Ngengwa. And he knew who assisted him in doing so. This is the person he was calling. Come, give me that statement that you've made to the police. What bothers me is that he's got the audacity of giving his official email for that statement to be sent, well knowing what he was doing. Fortunately, the witness said to which I did not respond to the message and I did not send him my statement. We are going to court on Monday. We need this statement on Sunday. I don't know what he intended to do. I was looking at Exhibit D. I do not see him disputing this fact. Safe to say, I didn't know it was a witness. That Mali, Your Worship, on the inference, the only irreversible inference who can throw that he knew. That is the second ground. D, because I'm following what the law is saying, one or more. Where there is likelihood that the accused, if he or she were released on bail, will undermine or jeopardize the objective or proper functioning of the criminal justice system. Page 19 of Exhibit GSM5, Your Worship, says the order of the Equality Court. The following order is granted. It is hereby declared that the utterances made by the respondent against the municipal manager of the City of Cape Town, Mr. Lungelo Mbandazayo, Mr. Mbandazayo, constitute unfair discrimination, hate speech, and harassment. 2, this is the court order. The respondent is ordered to remove the social media posts dated 6 February 2023 and 10 March 2023, which contains the prohibited speech by the end of March 2024. Act and do this by the end of March 2024, or rather by the 4th of March 2024. 3, the respondent, Mr. Adams, is ordered to issue an unconditional public apology to Mr. Mbandazayo for the prohibited speech contained in his social media post on the 6th February 2023 and 10 March 2023 by end of 4 March 2024. Second order. 3, the respondent is ordered to enroll for and undertake a program of racial sensitivity training at his own expense by end of 30 May 2024. Importantly, the fourth order, the respondent is ordered to file a report to this court and serve it upon the complainant, evidencing his compliance with paragraph 2, 3, 4 of this order by 31 May 2024. What's his response? Lock me up. I won't apologize to that puss. The Equality Court finds that I've discriminated against the city manager, who's discriminated against me, against us. Fuck the court. I'm not going to apologize to that. I'm not going to mention that name again. Fuck the court. In his exhibit D today, he was going all around saying the PKTT did not comply with the court order, that he went to the High Court of Judge, just forgot the name, may I apologize to the judge, a rule Nisi, where the other parties were not even given an opportunity to respond. But he himself says, I'm aware of this court order, but I'm not going to apologize. Fuck the court. Then the complainant said, okay, you are not apologizing. You are not giving me a report that you have enrolled with the program, we have apologized publicly, we have removed the post. She goes and opens a charge. As evidenced in our affidavit, he himself says it on his paragraph, where he says he's got a case, Cape Town. If I can go to that quickly, Worship. Cape Town Central 311 of 3/2024. Now, has the state not established that he's got a history of giving the courts middle fingers? Your Worship, the court can choose one of the three, because the law allows you to do so. If it has been established, on the two, at least we showed the attempt. On the other one, we proved the existence of his criminal conduct. Going to A, where there is likelihood that the accused, if he or she were released on bail, will endanger the safety of the public, any person against whom the offense in question was allegedly committed, or any other person, or will commit Schedule 1 offense. The very same submissions I've made feature here. I'm not going to apologize to that. Fuck the court. So, and he's not telling you, Your Worship, on his affidavit as to how that matter was resolved. It's not a question of saying it was simply withdrawn. The NPA had to drag him, to speak to this man, try to find some common ground. That is evidenced by what? The video footages. He was addicted, if I can use that word, to media frenzy during this time. Every day he would call the media, come, I want to tell you something. He goes to his TikTok and he want to say, he was just addicted on being heard outside there. And in the process, he's calling people names. The Equality Court said, stop doing it. Enroll to a course to deal with your problem. And he said, no, I'm not going to do it. Self-proclaimed people who are criminals and all. That is a member of parliament. And this I understand perfectly why, in his affidavit, he wants to confuse the two issues. On one, he is a member of parliament as appointed by his political party. And he becomes, two, a member of a portfolio committee by virtue of him being a member of parliament. And there are rules and regulations that operate with the committee. It does not take away his responsibility as a party member to go and do whatever he wants to do on the benefit of the party. He can go to Westfield Prison to meet people on the benefit, him as a party member. And say, look, I'm here to understand how are the prison conditions. And then he reports to his party, and then they say whatever I want to say. But you cannot come shield yourself as a member of a portfolio committee and do what the job that the portfolio committee did not ask you or mandate you to do. He knew very well, Your Worship, that had he come there as a member of the party, he was not going to get escort. He was not. He was not going to get an official escort because he is as a personal person in his personal capacity as a member of the party. Put loosely, if I can read this. We have collected this evidence so as to put the court at ease. It is important to distinguish between an individual, or maybe let me start here. Members of parliament are fully entitled to exercise their constitutional oversight responsibility in terms of the Constitution. In terms of the Constitution and the rules of the National Assembly. However, where a member purports to act on behalf of a portfolio committee or to carry a committee mandate, this requires prior and formal authorization through the committee processes, which we have investigated and established there was none. In terms of the rules of the National Assembly, portfolio committee act through collective decisions of the committee. No decision was taken by the portfolio committee on police authorizing the applicant to act an oversight visit on parliamentary engagement at Westville Prison. None. And he knows it. Is that not a misrepresentation of facts? Your Worship, my colleagues can tell you. I even asked, perhaps we should get a breakdown of what cost did the Metropolis incur to take this man. I mean, petrol is expensive these days. I mean, everybody knows that. For him to be transported from King Shaka to Westville and back, and those members did not have to do their other official duties. Maybe the other members who would have been stuck on the entry, they would have come to assist, but there is this member who says, I'm a member of parliament, here's my identity. He goes in to the prison with the phones, takes a video of the inside of the prison, and does not report back to portfolio committee and say, my fellow members published this. Your Worship, there's a reason why the supplementary affidavit was submitted, which is Exhibit C. This morning, if I can get that Exhibit C. This morning, Your Worship would have listened to one of the video footages. In fact, I don't think it's a video it's him addressing the media. There was a question and with a journalist, where he says, the hitman said in that statement that Dumisani Khumalo had a hand in the killing of Magaqa. By virtue of Dumisani Khumalo being in the crime intelligence now. There is nothing on SM7 about Dumisani Khumalo. Nothing. There is nothing on the newspaper article which he arranged that this statement must be published on about Dumisani Khumalo and the killing of Magaqa. This is the same Dumisani Khumalo who told the family right from the beginning, I'm the member of this PKTT investigating your matter. Imagine the family reading this and saying, this man lied to us. That is the extent of the distraction or obstructing or defeating the ends of justice. That's the extent. Get your facts correct. Then publish what you know is true. Your Worship, is this the man that is supposed to be granted bail? I beg to differ. One might say, Schedule 1, not serious. Please go deeper. We request, go deeper. You'll see the intention of the applicant. Your Worship, if may I just convene. Forgot to ask to submit one legal thing, Your Worship. It took years for the matter of Sindiso Magaqa to even start. There were a lot of problems. And eventually in 2023 it started, where charges were put to the accused, including Mr. Ngqeng. And he stood up and said, I'm pleading not guilty. He was legally represented at the time. It was televised nationally. Maybe some of the members who are now televising this were even there in that court, where he said, I'm pleading not guilty. Evidence was laid. In January of 2025, the state was still to lead further evidence. Everybody in the nation knew that man has pleaded not guilty. He goes to prison and obtains this kind of a statement, SM7. And not only obtains it, publicizes it in the middle of a trial that took years to take shape. There was a judge sitting, listening to the evidence. They are co-accused, Mr. Nengwa is charged with, who also pleaded not guilty, and still waiting for the state to lead further evidence to implicate them in the charges. There's a family of the deceased listening to the evidence. He goes on and publishes this. And says, the hit man told me 1, 2, 3, 4, 5. This man has not been found guilty at the time. It's only later, after this statement was published, that he came in and made 220 admissions and pleaded guilty. But at the time, none. And he calls this man a hitman. Your Worship is sitting as a presiding officer. I need not explain myself or make more submissions as to what effect can that do to a presiding officer. They are co-actually sitting. They are right. And he goes on his video footages and laughs and make a mockery of what he has done. Those will be my submissions. We've established the existence of at least, oh, I was doing with A when I forgot to make, Your Worship, when we look at paragraph 5, subsection 5, in considering 4A, Your Worship can look at 5C. Any resentment the accused is alleged to harbor against a person against whom the offense in question was allegedly committed, or any other person. We play the video. Who has arrested him? The PKTT. I don't have to interpret what he said. In each and every single footage, you can see the resentment that he has against the PKTT. We submit, we have established the existence of the 4 of the 5 grounds. Bail should be refused. Unless there's anything else, Your Worship, those will be my submissions. Thank you. May I approach Mr. Kangai? Oh, another thing, Your Worship, that I forgot. We will make a, oh, here is it. It's a, I think I will show it to Mr. Kangai first that these are the videos that we have put in the USB for the court to watch. But can I approach Mr. Kangai for the date? Yes. The other 3 accused will have to Friday, but maybe we'll start with them, with the judgment, and then we'll argue after that. Yes, I saw that. I think the worship can start with that judgment on Friday, and then we can
I do work, just for your information, and you know the work that I do.
I understand. But it's just a request.
And I have a full row for Friday.
11:30 Friday?
I would propose that we deal with it in the next 2 days, because on the 18th I started the matter in the High Court, and I'm only available thereafter on the 19th, on the 21st to 22nd of June. So tomorrow or Friday is suitable to me anytime.
What time on Friday?
We're in your worship's hands.
Is 11:30 suitable?
I think it is. I'm just worried about that bail ruling. Maybe your worship can start. 11:30. We will show this to our colleagues and then hand it over, even if it's after the adjournment. I don't know whether it's SM124, I think. Part 1, yeah. SM1. Transplant. Your worship, if your worship is. Then we can adjourn to Friday the 15th, yes. 11:30.
I will be ready, your worship.
Thank you, Your Honor. Thank you, sir.
May I take the pleasure of doing what I started doing when I was that is the role. Thank you. Exhibit banner. Exhibit banner. I think that's in a nutshell. A nutshell. This is E. Yeah. I hope in September, I will not movies.